The Human Rights Act recognises the rights of people in Queensland, and Queensland's law has a unique feature to make sure people's rights can be upheld. We are the only state to have a direct complaints mechanism overseen by the Queensland Human Rights Commission.
The human rights complaint mechanism is unique to Queensland. I'm very excited about it because it gives people the opportunity to actually access justice when they feel that their human rights have been unjustifiably limited. We saw some good examples of this during the COVID-19 pandemic, where people in Queensland who were banged up in hotel rooms that were just not appropriate for their situation were able to actually make a complaint to the Human Rights Commission and argue that their human rights had been unjustifiably limited. So people in Victoria and ACT in that situation would have to resort to some other form of litigation. But in Queensland, because of the complaint mechanism, that people were able to make a complaint. We were able to successfully resolve a number of those and have people moved out of inappropriate accommodation, which is fantastic.
This means people can complain against public entities about their human rights treatment. Public entities are organisations delivering state government-funded services. This includes not only state government departments, but also community organisations, hospitals, libraries, emergency services, and services like public transport. There are a few steps. A complaint must first be raised internally with the public entity delivering the service. If the complaint cannot be adequately resolved within 45 days, the next step is to complain externally to the Queensland Human Rights Commission. Depending on the nature of the complaint, it may be referred for conciliation, which is a formal mediation process supported by the Commission.
It's really important to have a complaints mechanism just in terms of access to justice. So when a person does make a complaint to the Commission, before they complain, they have to complain to the public entity first, and a period of 45 days has to elapse before they can come to us. Once they do come to us, we will bring the parties together and try to resolve the complaint. If the complaint's unresolved, then the Commission can issue a report and make recommendations about the steps that the Commission thinks the public entity should take in the future to ensure that they are acting compatibly with human rights.
But what if the matter is urgent? In housing, this might be a warrant of possession or an eviction. In extenuating circumstances, the Commission will accept complaints earlier than 45 days. However, the matter will still need to be raised with the public entity first.
There is the exceptional circumstances clause, which enables us to act on a complaint prior to that 45 days. We have done so on a number of cases involving urgent housing issues. And housing is a fundamental priority for all people, and we do recognise that it is worthy of urgent treatment.
So what do you need to do as a public entity to be prepared? The Human Rights Act outlines new responsibilities for public entities. These should be incorporated into your complaints process. Is yours up to date? It will be important for community organisations to review and update their complaints process to ensure they are acting compatibly with the Act. An important aspect of acting compatibly is giving proper consideration for human rights before making a decision or taking action. It will be important to demonstrate that your organisation has given proper consideration if a complaint arises. You also need to maintain open communication with the person making the complaint throughout the process. If new information comes to light, you may need to look at the situation again and review the consideration given.
One of the benefits of the Act we've already seen across the whole public sector is public sector agencies and non-government public entities already moving ahead and looking at their complaint mechanisms and ways that they can improve it. So I think that's one of the great benefits. So already we see agencies dealing with their complaints more meaningfully and trying to catch complaints before they get to the Commission, which I think is really encouraging. Other than that, I think what they can and should be doing is looking at the types of decisions that they are making on a day-to-day basis and identifying which rights are likely to be engaged by those decisions, and then identifying any gaps in their delivery and how they can improve service delivery to, decrease the chances of a complaint being made in the first place.
Public entities will need to provide information and supporting evidence if a complaint is raised to the Commission. It will be important that this evidence shows that the public entity gave proper consideration to the human rights before they made a decision or took action.
Well, the public entities can expect for the Commission to act very impartially, and we certainly won't prejudge the issue. Our primary role is to bring the parties together and to facilitate a resolved agreement. And if we can't do that, then in some cases we can issue a report and make recommendations about what the public entity should do to act compatibly.
Ultimately, the complaints mechanism is designed to provide access to justice for people whose human rights may have been unjustifiably limited.
In 10 years, I would love for Queensland to be much more literate in human rights and for human rights to be a reality for people. So when people are able to identify when their human rights are limited and to take steps to actually protect their rights. I think human rights are often conceived as something that belong internationally, that actually don't really apply here and just are about prisons and refugees, when in fact what we know, and we can see this just coming through the complaints at the Commission, human rights have far broader impact on people, including during COVID-19 with people in hotel quarantine, for example. So my vision is that everyday Queenslanders will be able to articulate what their human rights are, and that advocates, particularly in the housing sector, will be able to advocate for their clients, but using human rights arguments. So taking human rights out of the hands of academics and lawyers and putting the rights into the hands of everyday people in Queensland.